Yeah, thank you very much for coming again. And so let's get started, session one. And first of all, so thank you. Yeah, let me introduce the great panels for session one. And in my right side, so Mr. Mark Fripp, and he is a partner at Kaplan & Ellis LLP, where he helps lead the litigation department and serves as one of 20 members of the fund's worldwide management committee. And prior to joining Cochrane, he was at the U.S. Department of Justice, where he serves as a Deputy Attorney General of the United States after being anonymously confirmed by the United States Senate. So next to Mark is Ms. Mori Muzo. My pronunciation correct?
Mazer, you would never know.
She is the acting chief of the Money Laundering and Asset Recovery Section, MLARS, within the Department of Justice Criminal Division. She oversees investigations and prosecution of financial institutions and related individuals and entities for any criminal violations, including violation of money laundering laws, U.S. economic sanctions, and the Bank Secretary Act, investigations of complex third-party money laundering schemes, and investigations of kleptocrat. And next to Mori is Dan Karn, Mr. Dan Karn. So he is a partner at Davis Polk in the White Collar and Defense and Investigation Group. He represents companies and individuals in government enforcement matters, including internal investigations and in compliance matters. Next to him is Professor Jennifer Oren. She is a professor of law at New York University School of Law. Professor Jennifer Oren is an internationally recognized expert on corporate criminal enforcement, author of more than 50 scholarly publications. She currently is the associate reporter for enforcement for the American Law Institute's Principles of Law on Compliance, Enforcement, and Risk Management for Corporations. Okay, so we have a really great panels here, and this session, so I expect and hope that very interactive. And this year, so there are a lot of mics in front of you, and you can jump in and make any comments during our session. And so please do cooperate with our session to make it very interactive and enjoyable for you. Okay, so I will share the slide. Okay, let's start with our white-collar enforcement statistics. So, Dan, would you like to explain a little bit about the statistics?
Can people hear me?
No.
Guys, continue to turn yours off first.
Okay.
Here.
Just one other thing that I'm not very good at is technology, so apologies. So we have up here the statistics from the criminal division fraud section, and so that's the section that Glenn Leon, who you just heard from, heads up. The reason we use these is for two reasons. One is they actually do a very good job of keeping track of it and putting it out on the web so that it's pretty easy to pull the statistics. But also, I think they are one of the most prolific enforcers of corporate crime and white-collar crime within the Department of Justice. I think together with Molly's section, the money laundering and asset recovery section, they make up the bulk of white-collar corporate criminal enforcement, obviously working together with a lot of the U.S. attorney's offices. And so these are the statistics for the prior 3 years out of the fraud section. And there's not a lot of trends that I would necessarily take away from this. There was a brief period of time when the new administration came in where you saw the numbers start to go down. That's not that unusual when a new administration comes in, particularly an administration that likes to be more involved in the process. That can sometimes slow down the pace of corporate enforcement. But as you heard Glenn say, and as I'm sure Molly's going to talk about, there have already been a number of very big resolutions out of the Department of Justice this year in the corporate side of things. Generally speaking, the last 3 months of the year, you also see a number of additional resolutions. So I would expect that there's probably going to be more corporate criminal resolutions this year than there have been in the past few years. There's also, as you heard Glenn say, a number of trials. I think it's also important to remember, though, that the announcements of guilty pleas and trials and corporate resolutions is really just a part of the story. I think another important part of the story is how many investigations are being opened, and I think to that end, you've heard the department speak and Glenn speak, and I'm sure Molly and others will speak about the efforts to try to generate new cases through the whistleblower program, through the ICAB, the International Corporate Anti-Bribery Coordination efforts, through data analytics. And so certainly what we are seeing on the defense side is that there are a lot of investigations that are being opened, and so I think that is also at a very frequent pace. But then I think the last piece that sometimes goes unnoticed and it doesn't really get spoken about because it doesn't fit neatly within the carrots and sticks piece of it. And I'm not really a fan of carrots, so I prefer carrot cake, so I'll say carrot cake and sticks, or, wow, okay, that was apparently a really bad joke, so sorry about that. Anyway, chocolate cake maybe. But I think one thing that sometimes gets forgotten is just the decision that this is not a case that the Department of Justice should be pursuing for any number of reasons. There are a number of cases where the SEC, for example, brings a case and the DOJ decides that they're not going to bring one. That is the Department of Justice exercising its discretion appropriately to say, does this really warrant a criminal case for any number of equitable reasons based on the conduct, based on the company's cooperation, and any number of factors. And I think the department, there shouldn't be a lot of criticism if the department is not as active in the corporate space as maybe it had been in prior years. I view that as a positive thing. I think companies and the community should view that as the department appropriately exercising their discretion. But with that, I will leave it to others who are much smarter than I am to add on to that.
Thank you, Dan. So Mark, so would you like to add anything from your perspective?
Yeah, well, good morning, and thanks to the Japanese Embassy and everyone for attending. Almost inevitably, just given the history of this conference and how long and deep and vibrant contributions have been from the fraud section and from the money laundering area, we look at statistics there because they're readily available. There are other areas, though, that are important that I think it'd be remiss if we didn't recognize, particularly for folks from overseas who are going to be speaking with companies overseas and whatnot. There's been a lot of activity in the antitrust space, okay? So in the antitrust space, that's gone both criminally, where just objectively, the record of success from the department's perspective has been mixed. There have been convictions, there have been acquittals, there have been hung juries, etc. There's also been activity on the civil space, because you can have civil activity both from private litigants and from the Department of Justice in the mergers and acquisition space, for example, alleging that a proposed merger is going to be unlawful or lead to an unlawful aggregation of power. And in that space, the record in the courts has also been mixed. Generally, probably more than one might guess, DOJ has lost those. That statistic is misleading as to the impact of economic activity because the rigor of review for proposed transactions in the antitrust space has been very, very extensive. And the specter of that review, with the attendant costs and time that it's going to take to get a deal cleared, even if it can be cleared, has had a pretty substantial effect in the U.S. economy as to whether mergers go forward as proposed at all, or whether people choose to do smaller things or don't choose to do the deals at all. That's not really, at some level, mostly a law enforcement dynamic, but it's a profound dynamic in terms of economic consequence, both for U.S. companies and for foreign companies, anyone who might be involved in those affairs. What's interesting in particular is some of the topics. America's a very divided country. People find it hard to agree on things to the point of absurdity at times, okay? And it makes things cumbersome and inefficient for people unable to agree on things. But maybe unexpectedly, one area in a very divided election that America faces this November is that both of the sets of candidates are quite keen on the idea of aggressive antitrust enforcement going forward. So whatever disagreements there might be about ESG or whatever it might be, there's a million things. There's more things they disagree about than that they agree about. But they do agree on the desirability to have aggressive antitrust enforcement going forward, including in the tech sector. And I would think the tech sector would disproportionately affect Japan, a very mature, vibrant, intellectually high-powered economy. The tech sector antitrust enforcement will be of interest. You'll also see it in heavy industry, steel, things of that sort as well. And so that's an area to keep in mind. Another area where you see a lot of activity in the U.S. Out of the Justice Department is the Consumer Protection Division. That's a newer division in terms of certainly criminal law enforcement authority. That only happened under Attorney General Sessions, within the last 8 years or so. That group is quite aggressive. I think many of the people there are pretty junior, and so they're kind of feeling their way, but that's another area where companies are going to see activity, and I suspect there'll be development in the law. The one last thing I would say is that you see an intertwining. This has been going on for 20 years, certainly accelerating, an intertwining of state law enforcement authority with federal law enforcement authority. Sometimes that's in criminal areas, sometimes it's criminal hybridizing into punitive civil authority and whatnot. And that used to be a fairly modest phenomenon of a handful of states where the attorney generals really were leading the vanguard on that. That's very much become a national phenomenon now. Not in each and every case, but it's by no means unheard of. It's not even unusual to see 48 state attorney generals moving in a particular area under a variety of theories, and the Justice Department also involved. So when you're thinking about it from an economics perspective, when you're thinking about it from a corporate leader perspective, from a lawyer's perspective, a judicial perspective, that dynamic, that's very different than it was 25 or 30 years ago. You just didn't see that then. And I don't think that's going to change. I don't know that it'll accelerate further just because it's basically matured into that very vibrant set of different vectors in an enforcement space. But it's very difficult to believe that that's going to move backwards with less activity from both state and federal actors. And Congress as well. Congress often gets involved in that space. So those would be my observations.
Thank you, Mark. So Maureen, so would you like to supplement from your perspective?
Eventually we'll be able to operate these mics together. Is it too close? Might be Really causing a react. I'm really causing a react. I do have an electric personality. It's true. Here, give it to me. I'm just gonna do that. It can't be that big. It's gonna be like. Okay. Well, we'll try this anyways. I'll just stay a little bit farther away from it and project. Thanks so much for having me. I really appreciate it. Usual caveats. I speak for myself, not for the Department of Justice. I just want to echo what I heard Dan and Mark highlight here. So I think the corporate enforcement trends are really strong. Glenn outlined some of the efforts the fraud section is taking. We are on track to have more corporate resolutions in the criminal division than ever. But really importantly, as Dan highlighted, one thing we're really focused on is how can we uncover these white-collar and corporate schemes? How can we find out about this misconduct? So for a very, very long time, we've had a corporate voluntary self-disclosure program. We're the first part of the department to have that. That was pioneered in the fraud section almost now 10 years ago. It's been highly successful. It offers a wide variety of benefits to companies that want to come in and self-disclose. But one thing we've been really laser focused on in the last few years is how do we get individuals to come in and self-disclose? Juries want to hear from people who saw the misconduct occur. Nothing really gives us the strong evidence like having an insider who can tell us about the case. So over the last few years, we have developed a series of policies that I know we're going to talk about today, really designed to incentivize individuals as well as companies, right? So as the Deputy Attorney General said, when everybody needs to be first in the door, nobody wants to be second, and getting individuals to come in, whether it's under our individual voluntary self-disclosure program where we offer the benefit of a non-prosecution agreement to individuals who have been involved in criminal activity and come forward voluntarily to effectively confess to us and cooperate with us, or under our whistleblower program, which is really designed to incentivize those who are not substantively involved in the scheme but who see something to say something. Getting those individuals to come in helps us hold companies accountable, helps us prosecute more individuals at the core of the scheme, and also sends a message. And I think we've seen, and Glenn spoke a little bit on this earlier, we've really seen this happening in companies, sends a message to companies to step it up in terms of their compliance programs. So every time we have a corporate resolution, what we see from esteemed counsel, like those around me coming in, they study it, they look at it, they advise their clients about it, and we see companies change their compliance programs. We see them take additional steps. We see them do things like encourage whistleblowers to come forward, try to address problems before they arise. And frankly, that's one of our chief goals, right? While we want to prosecute all the crimes that happen, we really prefer that those crimes don't occur in the first place, that companies take steps to stop those crimes before they even get to the point of criminal misconduct. So wherever we can get companies building stronger compliance programs, coming in earlier to the department, that really helps us diminish the impact of criminal activity, but also go after the individuals involved, which has been the goal of all of our policies have been directed at over the last few years.
Thank you, Maureen. So, Jennifer, is it okay to supplement anything?
I could if you want, or you could move on if you want.
Please.
So I definitely think that I was sitting here thinking, I've been thinking about corporate enforcement policy, I realized, for a little over 30 years, which was a kind of unnerving thing to realize sitting in this room. And over that time, I've seen a real revolution in the way the DOJ has approached it, and it is having a really serious effect in terms of, I want to underline what was said earlier, actually originally by Glenn. The most important thing is the individuals. That has been one of the most important changes, is making sure that the individual wrongdoers are held liable, and that individuals, if they get difficult and don't want to plead, actually end up going to trial and hopefully get convicted if they are guilty. And I think what the DOJ has done in terms of providing enhanced certainty to companies that self-report is also important and has had an effect. I do see in the data some reasons to think the DOJ is right to think it needs a whistleblower policy. And that may be no offense to any companies. All right, a little offense to some companies. And partly relying on Eugene's study coming out of whistleblower programs. As I always say, I think that you're doing an amazing job detecting, but I think you're detecting the ice cube on top of the iceberg and not even the tip of the iceberg. I mean, I think there's an awful lot of stuff below the waterline. And if I listen to how many declinations, which is also telling me how many self-reports that really hit everything and no aggravating factors, it's relatively small numbers relative to the amount of crime. And what psychology evidence tells us is the single most important thing to deterrence is the certainty of detection, because people we tend to ignore low probability events. For the US, it would be, will real estate prices in California, Nevada, and Florida all move together? If you think that's unlikely, you get the financial crisis. So we ignore low probability events. So we have to be sure employees think, if I do this, I'm really likely to get caught. And if I'm only maybe likely to get caught, you round down to 0, right? So I think we're seeing both the success of what's been done, but also the reason that it's absolutely vital we have a whistleblower policy that we may need to revise a little bit to make it work. Because we still have to detect more, is what I would say.
So I always love being on a panel with Jennifer and esteemed people like this, because I always learn something as well. I would push back a little bit on that, because I do think that I do think that there are companies where there is significant misconduct going on. I also think that in large part due to the department's efforts, I think that a lot of companies are truly trying to get it right and are trying to stop misconduct. And so, sure, there is other misconduct out there. Sure, every company, no matter how well-intentioned it is going to have misconduct. And I don't think the department's goal should be to get every single instance of misconduct reported to it. Number one, I don't think that they have the resources to even begin to look at it. But number two, I think part of the goals of the department has been to encourage companies to have these internal systems that catch misconduct, stop it, discipline employees, and fix the problem, remediate, and don't report it necessarily to the department because it may be a more minor issue or not a significant one. The types of grand corruption or grand fraud or massive antitrust conspiracies, certainly I think the department wants to get, and we can have a discussion about all of the areas in between and where the line is of what they're trying to encourage. I agree with Jennifer that in terms of carrots and sticks, and I won't make my carrot cake joke again, so again, apologies about that. But there are really two ways of coming at this, and I think the department is appropriately focused on both, on the carrot side and on the stick side. So the stick side, certainly the question I think that goes through a lot of companies' minds is, how likely is it that DOJ is going to find out about this anyway? And how much worse is my penalty going to be if I don't disclose it and DOJ finds out about it? And so DOJ is, I think, they're focused on that. They're trying to continue to come up with new ways of identifying cases. But then there's the carrot side, because to Jennifer's point, you're not going to be able to capture everything. You're not, even if you're using data analytics, even if you have a whistleblower program, even if you are doing this international coordination, you're not going to catch everything that's going on. And so then you turn to the carrot side, and again, I think, and Jennifer was a large part of the reason I think that the department put forward the corporate enforcement policy initially, and And I think that was a very big step in the right direction. But I think somewhere along the way there is this hyper intense focus on, you know, this corporate enforcement policy and the, you know, everything has to be done according to the corporate enforcement policy. But I think from a company's perspective, and I would certainly welcome Mark's views on this, as he's obviously has a ton of experience in this space. But if you're a company and you're thinking, what is the carrot? Okay, I can walk this in, but then I'm going to have a 3 or 4 or maybe 5 year investigation. I'm going to spend tens of millions of dollars going through this investigation, and best case scenario at the end of the day, I'm going to get a public declination that is very likely going to lead to follow-on lawsuits by foreign authorities, follow-on lawsuits by shareholders or by customers or third parties. If you think that your likelihood of getting caught is 50%, 60%, 70%, it just may be worth it for you to take that 30% chance, because it is not, I think, still a significant enough carrot to say you can come in. Now, I think add to that, and again, I'm not faulting the department for doing this. They you know, have been very transparent about what their policies are, but it just seems like the corporate enforcement policy is getting tougher and tougher to actually meet those standards. And so you can walk in thinking, okay, great, like I got in before the department reached out to me, and as a result of that, I am now going to get this, like, sure, I'm going to spend tens of millions of dollars, sure, this is going to be disruptive to the business for the next 3 or 4 or 5 years, and sure, it's going to be a public shaming, and maybe there's all these additional follow-on suits, but at least I'll get a declination from DOJ. Now, DOJ may say, not so fast, you didn't actually qualify for all of these little technical reasons that even though you thought you were going to get a declination, you're not. And I think, in my own view, this new amendment to the whistleblower program is a step in the right direction, because it's saying that a company that runs in, if they get a report from a whistleblower, we're going to run in, you can still get a declination. But I think there's a lot of incongruity between that and how they treat everything else.
Thank you, Dan. So, and I think so we can continue this discussion, but we should move on to the next topic. And so one of the most important topics this year, and addressing the uncertainty of detection, so just Jennifer mentioned, is the DOJ Corporate Whistleblower Award Pilot Program. And so Dan, again, so could you briefly introduce the outline of this guideline, and Maury, so if you can, so please briefly explain what the original information is.
Sure, and we have the person here who oversees the whistleblower program, so she will correct me as I mess this up, and then she will certainly supplement with more helpful information. But I think the interesting thing about what the department considers original information is they can still have an ongoing existing investigation, but if a whistleblower comes in and provides something that they don't already know, that is considered original information. And the reason that that's relevant, and again, coming back to the decision of if a company is going to voluntarily disclose, in the company's mind, they have to realize that if they voluntarily disclose one investigation, an employee who is aware of something else that management may not be aware of can run into the department and disclose it and still get an award and still qualify for the whistleblower program. So original information just means something that the department isn't already aware of, but Molly should certainly provide a more fulsome answer.
Well, I think this just really gives me an opportunity to jump in on Dan's last answer, so I appreciate us moving on to the whistleblower program. So look, we're really excited about the whistleblower program. As Jennifer highlighted, it is one tool that we have to try to bring in more individuals and uncover more misconduct. I think Dan's absolutely right. Companies are making tough decisions when they uncover misconduct about whether or not they should come in. They are reviewing a whole landscape of options. They're thinking about the length of time investigations will take, what the likely consequences are, whether or not the conduct really appears to be criminal. Do they know at the beginning? What we're trying to do is put pressure on those options so that companies will come in. When they know that we are more likely to uncover the crime, that changes the calculus. That tells the companies we should come in. And what we're trying to do with our whistleblower program, so in March of 2024, the Deputy Attorney General announced our 90-day policy sprint. And experts in MLARs and in the fraud section, which Glenn heads, got together and studied the existing landscape. We reviewed the rules, we reviewed the statutes, we talked to existing federal programs, we talked to experts and stakeholders inside the department, outside the department, the whistleblower bar, academics, white collar bar, in-house compliance, to really understand, what are the right incentives. And we got a lot of feedback here. You won't be surprised to hear that the whistleblower bar encouraged us to model our program exactly on the SEC program, which provides straight 30% rewards based on the entirety of the penalties. We took a lot from the SEC program, including the definition of original information that Dan was talking about, so that whistleblowers who come in, even when an investigation is already open, but they bring us something new, they still may be able to benefit from that, right? So the idea of original information here is, tell me something I don't know. Tell me something new, right? Because we want to further our investigations. We want to move them more quickly. We want, so for example, I'll speak a little bit out of my area, but like in FCPA cases, maybe they're uncovered bribery in one country, but maybe the whistleblower has information about a whole other bribery scheme in a different country. Come in. Tell us about that. That both helps us uncover misconduct, but it also pushes companies to have strong compliance programs and do a thorough vetting when they uncover misconduct, right? Not just focus on a narrow issue, but do we have problems elsewhere? So really here, we are trying to get any sort of meritorious information, new information, and our program's already shown success. So we've been in business now 12 weeks. We've had now, as of today, over 200 unique tips. We are reviewing those tips. Look, any program open to the public is going to have a little bit of signal to noise ratio. Not every one of those tips is going to be worth following up on, is going to be meritorious. But right now we're seeing dozens of these tips that actually provide information related to misconduct. And it's having an impact in the corporate world as well. Dan noted that we made an amendment to the CEP. This says that companies that get a whistleblower to come into them, they can come to us within 120 days. Even if we've already heard from the whistleblower, we will count that as a voluntary self-disclosure. And we will give them the benefits of our CEP. This is a huge departure. Previously, I know Dan described it perhaps as technicalities, but the technicality is, if we had heard about the scheme from somebody else, you do not qualify for voluntary self-disclosure credit. Here, we are making a narrow and focused exception because we want to encourage companies to take whistleblowers seriously, and we've already seen that having results. We already have one company that's come in and told us they are reporting under our CEP exception, so we are seeing real-time and, frankly, really quick impact of these proposals, I think, because we're being transparent and because we're putting pressure on all fronts with this whistleblower program for corporations to uncover misconduct.
Thank you, Maureen. So I have one question. So recently, we observed a press release from the SEC that they give two rewards for two whistleblowers in the same case. So when we observe the definition of original information under this whistleblowing program, it looks like this whistleblowing program also is designed to award more than one individual. Can you give a brief explanation about
It is. So it's designed to reward more than one individual. So sometimes that could be two people together who come in. Oftentimes, I think in the SEC's experience, it would be two totally separate people who come in. As long as they otherwise meet the qualifications of the program, they're both bringing original information. And original information, it includes, I was in the room when people were hatching the scheme and I heard about it and took notes. But it can also include original analysis. I analyzed the data. I discovered some misapplication. I wasn't in the room myself, but I can tell you through my analysis, I can see a fraud scheme is going on. So if two people come in, both can be eligible for a reward, and we'll consider the information they provided, how it helped the investigation, and consider whether both of them would receive an award.
Thank you very much for that clarification. And so we can move on to the next part, which is a minimal participant. And Jennifer, so I think this, so idea is quite important from your perspective. So could you give me your observation in this on this town?
So I first just wanted to say that I think this new initiative is one of the most important things the DOJ has done in a very long time. I mean, in addition to all the other reforms to the corporate enforcement policy. And I think it has the promise to, over time, significantly improve our chance of detecting misconduct, but it also, I think, may very well significantly improve compliance. I mean, because companies are going to have to change the relationship between compliance and HR and their approach to internal reporting, given this. But for this to work, given the relatively low risk of detection right now, if you're a whistleblower if you're someone with information who thinks that if I report, I'm not going to get a reward, and worse, I might get convicted, you're going to be not inclined to report. And so it's really important that we make sure to design the program so that the people are willing to report and the people with information are willing to report. The program has a different cutoff for who can report than the SEC. So the SEC drew the line at individuals who directed, planned, initiated, or were convicted of misconduct. So they drew the line pretty high and said, as long as you're implicated but not at the top, you're still eligible. And that's going to bring in a ton of people who were lesser lights and might not actually be people you care enough to take to trial, but who have information about the misconduct. The DOJ has drawn it at minimal participant as defined under the U.S. sentencing guidelines, and minimal participant is really minimal participant. I mean, it's really someone you can't get, and given how aggressive we are, we can get almost everyone who
Commits crime.
well, not just commits crime, was sort of in the aura and lifted a finger. Even if an outsider might not think they're super duper implicated. I mean, we have a big tent on who could be an aider and abetter or a conspirator. I mean, we have very broad. So I am concerned about that knocking this out. Now, I understand why the DOJ did that, because if you might need to put the person on the stand, they're kind of useless once the defense attorney says, and so did you get, off altogether as a result of your testimony? That's not a good look. But
And recovered $20 million.
And recovered $20 million. So I do understand why the DOJ did that. I find myself hoping that there will be a way to amend it to bring some gray implicated under the tent if you don't actually need them to testify at trial, because you won't always. So that's where I see some potential issues in terms of whether this is going to work, but there may be enough misconduct that actually you'll be able to get a lot of information anyway. And then the other thing, just to remind everyone, is that this is only applicable to offenses that aren't covered by another policy. So just correct me if I'm wrong, I think that would mean that both the revised you can report within 120 days, and the whistleblower would not apply to reports of FCPA by publicly held companies that are listed in the US, because the SEC whistleblower program would apply to that. And that's, I mean, I understand why you did that limitation, but it's an important limitation.
Maybe I can just really quick. So maybe on just 2 points that Jennifer raised. So yeah, this program is meant to fill gaps. There are very successful existing whistleblower programs across the federal government, the SEC, the CFTC, the Civil Division has a KETAM program geared at public healthcare fraud. So what we're trying to do is bring in whistleblowers who are in the gaps. But to Jennifer's point about, what would be covered, what wouldn't be covered, we're really encouraging people to come in and report. If you're not sure, come to us, ask us, call us. If you think you have something that falls outside the 4 program areas we've identified, but isn't otherwise covered by another program, call us, come to us. And particularly the FCPA example is a good one, right? There's a robust whistleblower program at the SEC related to FCPA violations by issuers, but sometimes those schemes can be broad, they can be far-reaching, they can involve some issuer conduct, some non-issuer conduct. So we're really asking people, if you're not sure, call us. And what we're seeing, unsurprisingly, is people submitting to multiple programs. And that's going to let us make an assessment about what's covered, what's not covered, where there might be gaps to fill, where the program might have room to expand. So on that, right now, we are quite focused. We're meant to just really fill those gaps, but while we study the program during the pilot period. On the culpability point, just very quickly, look, that was a really conscientious decision. We heard a lot from the whistleblower bar, exactly having Jennifer's perspective, right? People who are involved in crime are the best people to tell you about the crime. This just makes total sense. But we're prosecutors. We have different tools available for people who are involved in crime. For those people, we can prosecute them, we can offer them cooperation plea deals, and we have an individual voluntary self-disclosure program that gives them a non-prosecution agreement if they come in first. So we made a conscientious decision to limit this to people who are minimally involved or less, because from our perspective in the criminal prosecution space, we should use those other tools to go after people who are more involved. And I know Mark wants to jump in.
I find this area fascinating. This is not new, really. Some of it's new, sort of, but as alluded to, this particular program occupies certain interstitial space in programs that have been advanced by the SEC, by FinCEN, by the CFTC, by the Civil Division at DOJ and whatnot. Not to say it's not important, it is important, and these various nuances play out differently in each of the different programs, and people should be commended for thinking about them in good faith about what the right answer is. What I think the society, political actors, etc., are going to have to think about and grapple with going forward, this whole issue of whistleblowing is big business, okay? So, and Dan alluded to this somewhat, you don't just have a whole organized KETAM bar and whistleblower bar with lawyers who sometimes have their own private planes that they've generated through whistleblowing suits. You have funders who fund KETAM litigation, right? So, and they solicit law firms. So they'll come in and they'll say, we looked at investing in payday loans, it's not that good, there's a lot of regulatory headache. We looked at investing in marijuana, we're doing that some, but I'll tell you, this KETAM thing is a bang up. And if you guys will do KETAM suits, do we have money for you? And on a strictly dollars and cents basis, it's extraordinarily lucrative. Extraordinarily lucrative. Particularly if you can elicit support of DOJ, and trust me, the people who invest in this area have statistics down to the 100th%. If we can get DOJ to intervene, our expected recovery goes up, bang, bang, bang. The judges are loath to dismiss the cases, bang, bang, bang. We're going to get trials, that's where we get settlements, bang, bang, bang. So this whole area, it's an interesting perspective just structurally about how law enforcement, and look, I don't say this with malice. I have a couple very good friends who are plaintiffs lawyers, but they will say over drinks, whether it's root beer or maybe even real beer, hey, look, if we can get DOJ to come in and make a case, or State Attorney General to come in and make a case, we just come and shoot the wounded, and we're just getting paid. And so, and they're not saying it with malice either. So it's interesting how, as societies move forward and all this stuff is intertwined together, you see inevitably an adjacency of law enforcement at the federal level with the SEC. Again, the state attorney generals coming into this space, and then very, very, very well-funded plaintiffs bar, and that's fine, but right, like that's part of the system. We have two parts of the system, but whether it's traditional plaintiffs trial lawyers of the sort that I suspect in Japanese boardrooms, people say, oh my God, America, that system's crazy. It's been crazy for 75 years. That group of plaintiffs lawyers, key-tail lawyers, etc., funders, etc., and it's all, I just think it'll be interesting to see, and a lot of these are pilot programs and whatnot, and we'll see where and how it all works out, how the system as a whole will try to reconcile deterring corporate criminal misconduct, whether done at an organizational level or an individual level, and then also thinking about whether or not are we over-deterring, are we incidentally rewarding people who we didn't think we meant to reward in the course of trying to deter criminal conduct. And it's super complicated, and it's going to take a long time, I think, for people to reach a point where they feel like on a systemic level it's been balanced out equitably.
Those are really excellent points. I will say the conversation there operates as an effective pushback to actually my concern about do you need to go broader, because it does suggest that although from my focus, which is how do we learn about as much crime as possible, you want to expand from a political economy and social culture focus, saying, you know what, if you're a criminal, even if you're just a little itty bitty bit of a criminal, we're just not giving you a bounty, appears as an important, that's an important argument for keeping it narrow. And that then means we may have less concern about these funders, because at the end of the day, they're not funding criminals. And the DOJ hopefully is not intervening unless there's good evidence of a crime, in which case people are getting wealthy, but they're getting wealthy detecting crime. And I spend a lot of time talking to whistleblower attorneys, and one of the reasons I've always said you've got to have a bounty provision and not just a we won't retaliate is most of the whistleblower attorneys will repeat the same message, which is their clients almost always really suffer from the moment they blow the whistle internally. And almost all of them disproportionately have clients who went inside first. And they didn't go outside until going inside kind of ruined their lives. And then they go outside. And just a we won't retaliate doesn't work. So you need this because of the huge cost emotionally and financially to whistleblowers of being a whistleblower. And here, at least, they're not guilty, which is, I hope, good.
Sorry, so just a couple. This is a very interesting area, obviously, and I think it has implications for the broader DOJ's enforcement of corporations and individuals. I think they are guilty, right? A minimal participant, like you could interpret minimal participant to be like the assistant who overheard something and didn't initially report it. I don't think that's what DOJ means. I think what DOJ means is someone who had an agreement of the minds with the co-conspirators to commit a crime, took some steps in furtherance of it, but is a much lower level person. And I'm hearing Molly say yes, so I think I have that right. And so, again, I think you come back to Mark's point, what is the department trying to do, right? What is the ultimate goal of the department? And there may be situations where a company has such a lax compliance program that it's almost negligence or willful that they're turning a blind eye to what's going on, and therefore the company should be held responsible too. But if you take a step back, a company is an inanimate, right? It's not a real thing. A company is made up of people. And oftentimes you're seeing a company with 20,000 employees and 4 of the 20,000 are engaged in misconduct. And is the department's goal to go after the company, get a big resolution, $100 million, and the minimal participant who engaged in the crime, one of the 4 people, recovers $5 million for engaging in a crime, and the company ends up paying this massive amount when these 4 employees were circumventing their compliance program and engaging in misconduct? Or is the department's goal to prosecute the individuals and to say, you know what, maybe we won't go after the company in this situation? Because even if the company doesn't deserve a reward, like a medal for, maybe they didn't detect it, they did enough here, and maybe we don't want to go after them. And I think it's just important to keep in mind, sort of the department keeps saying, our main goal is individual accountability, holding individuals accountable. And if you look at the corporate enforcement policy, when we put that out back, whatever it was, 2016, so, 8 years ago now, we had a discussion and we said, we are going to force companies to disgorge their ill-gotten gains because we don't think, well, it's interesting you say that because I want to contrast it with what you just said, because we don't think that you should be able to profit from your crime. Fast forward, and now we're talking about giving people who engage in a crime not just the ability to retain their salary or the bonus that they earned from it, but to give them millions of dollars for bringing the information to the department. Whereas if a company brings the information to the department, not only do they not get those tens of millions of dollars, but they have to disgorge tens of millions of dollars with what they earned. So I think it's a really interesting dynamic.
So, can I just come back? So, I love this conference because I learn from the best in the business, and also I really actually like hearing people tell me why I'm wrong. No, I always tell anyone who's around, tell me why I'm wrong.
I hear it at home all the time.
Because I need to be better leaving this room than I was when I came in, and this is making me better. I do understand your point that these people are not completely innocent. And maybe I just speak to too many whistleblower attorneys who obviously, but a lot of these people they're not the directing people. Some of them were eager beavers, but a lot of them were people who were more administrative and were pushed to do things that they were uncomfortable about. And then often, at least the lawyers I spoke to, went inside to raise it. I'm being pushed to do this, I'm raising it inside, and then I start getting punished. And there's a lot of that I hear goes on. And this is a pushback on this. And then the other thing I hear is companies that detect, and for the reason you said, I think the DOJ properly said you can't keep the benefit. And they go, well, that's going to be expensive and the investigations. So I'm going to terminate the crime and keep quiet. But then the individuals don't always get fully punished. This is going to give companies an enhanced incentive to go in. But the most important thing is, I do think, and again, this may be just anecdotal data, but often employees don't go to compliance. They go to their line manager or to HR. And my understanding is the culture of HR is not always a culture of let's really get down as far as we can. It's a very protect the company at many companies culture. If you can't prove it, we're going to wash it away. And so stuff is dying before it reaches compliance or investigations, and that's leaving companies blind. And I think if companies understand this policy, and then there's the small point that HR is sometimes a source of legal risk in the employment agreements it then adopts, which is a whole separate thing. I think that this, combined with the SEC enforcement on HR agreements, may start getting companies to recognize you can't have compliance over here and HR over here. You've got to bring the two together. And it might change the internal culture, you're right, at some cost. But I think if companies are then disciplining more, it will change the culture. But
Can I just ask a question? Even though, just to broaden this to the international arena, and I think my colleagues here can. You know, and I think that's. Okay. I just wanted to mention that I'd be curious to hear more about different perspectives too from, you know, in the UK, where I was just head of the Serious Fraud Office, and we've got other UK colleagues here. We don't pay for whistleblower information, and we find it offensive to even think about paying for it, although we have a new SFO director who's been out there saying maybe we should think about this. I don't know what practice is like in Japan, but it feels very transactional when you say to a UK audience, we're going to pay for this.
Do you mind if I quickly address that, Jessica?
Before that,
Yeah,
so
go ahead.
Mr. Roll, so you are new, so please make some comments.
Well, I've been listening with some interest to what you've been saying, and Lisa's hardly said the half of it. I wasn't quite sure whether I should be shocked or whether I'm just a wimpy, squeamish Englishman. But it's interesting, we've got prosecutors, we've got a former judge, and defence lawyers and academics sitting on the panel there. Where does the interest of justice get decided? Who is the arbitrator? Because suddenly, if I have sat as a judge, if it was revealed to me that the witness for the prosecution was worth 20 million, I wouldn't find his evidence terribly convincing. I'd find the 20 million rather more persuasive. And I'm just wondering whether this works in this jurisdiction, because very few trials get to a contest. People plead guilty. And do they plead guilty because the prosecutor says to the defendant, look, we've got all this whistleblown evidence, you're stuffed, so why not confess? And so nobody really tests the morality within a proper justice system of paying for evidence. But in the event that the defendant says, well, the whistleblower is telling fibs, I'm going to risk it, does the judge say, okay, members of the jury, this evidence is 20 million, this is $20 million of evidence sitting in that witness box over there. Its weight, its credibility is reduced by that enormous number. Or is that not a discussion that's ever had?
I mean, I'd be happy to jump in really quick on those points. So I think we were just in the UK, Lisa, and we've heard similar perspectives there and similar to your perspective. Look, I think one reason to us it was really important to create a whistleblower program is that, as Jennifer says, the people who come forward, particularly in these cross-border schemes, they are really putting their livelihood at risk, right? If they are reporting on a serious crime, particularly one they think the company is condoning, they are risking their jobs, they are risking their livelihood, they are, in some circumstances, particularly when we're talking about corruption cases, they could be risking their lives, they could be coming forward against powerful officials that are involved in schemes. So they take on a lot of risk to do this. They could be seen as, frankly, unemployable in their field. And so incentives, I think, are important. To your question about is this sort of right or moral or how is it tested, certainly we have had a lot of experiences doing trials that have involved whistleblowers. Those cases often start from a whistleblower tip, and then we develop significant additional evidence. Certainly, if whistleblowers testify, we have rules here about our discovery. The defense counsel, the court would understand that they might stand to benefit from coming into the government, right? That's something that would be disclosable. I think in most of these cases, the ones that are where we see real success is where a whistleblower comes in on a significant crime, they give us a tip that starts the case, and then we go from there. and we build a bigger case, right? We build more evidence. We bring in the people who were guilty. You know, to Dan, the conversation that Dan and Jennifer were having about culpability, we are allowing people who played a minimal role in the crime to come in the whistleblower program. Technically speaking, Dan's right, technically speaking, those people are people who the sentencing guidelines say were involved in the crime, but they are plainly among the least culpable. They are people who, frankly, probably would not often be prosecuted, but if they were, they're not playing a directing or deciding role. I think the sort of extreme circumstance that Dan's outlining where, you know, 4 people are engaged in a crime and the company is just, you know, negligent, oh, you know, whoops, they didn't see it happening and one person gets rewarded. Unlikely to happen. We all have our perspectives.
I think that's the most likely.
We'll all see how it all plays out in the next 3 years. But I think to this point, you know, we have heard concerns about why would you pay people for information and how does that work? And I think Mark will have really interesting perspective from the bench. But the idea is that they're taking a lot of risk and they're going to help us build a big case. And we're not just going to rely on their evidence. A case just built on the whistleblower, that's unlikely to succeed, right? We have to corroborate that. We have to do a thorough investigation. We have to get the other evidence to show that what they're telling us is the truth, what they're telling us is borne out, and that's what we plan to do with this program.
Yeah, to respond to Lisa and is it Lord Garner? Edward. You're very kind. So I think what you raised is very profound, very complex. It is very incongruous. For a wildly implausible set of circumstances, I studied law in England for 2 years, so I have great familiarity and respect for your system. It is wildly incongruous to British ears. I suspect it's wildly incongruous in most parts of the world, this idea that you would pay people millions and millions of dollars to be witnesses. In the US, the way that's handled, and sometimes it's more profound than money. You'll probably like some of what I have to say and not like it. People with even greater incentives to lie are presented as witnesses. What do I mean by that? So there's a famous case involving a man, I won't call him a gentleman, named Sammy Gravano. He was the number 2 in a horrible, horrible organized crime mafia ring in New York. He was a murderer, okay, a serial murderer, and he was given immunity to testify against an even more awful, murderous thug who ran the mafia group. And then he was given witness protection and whatnot. Someone like that, their testimony is inherently going to be deeply, deeply suspect, because he's basically being given his life. Sometimes in the US, where we have capital punishment, someone will escape execution by being a witness against one of their co-conspirators for whom the state is seeking execution. So it can be quite profound, and juries are asked to sort all that out. That said, just statistically, the phenomenon you're describing about companies not going to trial is real, okay? Very few companies do go to trial in these settings because the risk of conviction and an sort of managed debarment with the government is existential, for example, for a healthcare company. And we as a system, and I suspect over the ensuing decades, maybe something will be done to deal with this. They will plead to things, or they will accept government resolutions that they're reasonably confident that they would prevail on in court. But just the risk of that $250 billion healthcare company, even if there's a 5% risk of being convicted, $250 billion loss of value, just not possible to accept that. So the transaction is made. And in those situations, individuals who go to trial prevail with greater frequency than your average bank robber or, convenience store gun robber or something. They prevail with some frequency in that space. To the transactional point, again, and this goes to sort of how these structures are incentivized by the whistleblower bar, by the plaintiff's bar. They're directed at deep pockets, right? So there is no reward in whistleblower program for mafia, for child exploitation, for human trafficking, right? Could some of the offenses fit into that? Sure, maybe, kind of, but that's not really where people are going with these things, because if you're a whistleblower about some group of people trafficking, you know, it's just not where the focus is in terms of the organization. I'm sure there's been 1 or 2 or 3 cases that you can point out. Trust me, when they're having a conference at the American Trial Lawyers Association, they're talking about deep pockets.
Yeah.
So I'll acknowledge that there's been 2 or 3 examples in the history of the world, but that's not where the focus is. So I don't know where that, again, I think this is a fascinating area. I don't know where that'll leave the system 30 years from now, but for people from the UK or people from, I think, probably the Middle East, people from, this would be very incongruous, I think, in France, very incongruous in Switzerland or Italy. It is a uniquely distinctive, for better or worse, American feature.
Thank you, Mark, and thank you very much for your comments, Lisa and Rod Garnier. And one another thing that I can add is, so I think the attitude against justice, and also to what extent the financial incentive can be effective to detect and commit crime, I think could differ. So by culture, and I think we can discuss in later session so about the cultural differences, and that can change I think we should think about the cultural differences to discuss the legal system so as a whole. So I think we can discuss in a later session. And I think we can just 7 or 8 minutes, right? So, and I think I'd like to have your opinion and comments on so how should companies update their compliance programs. So Jennifer, would you like to start?
Well, I'll add a few things. So I think obviously this program should be incentivizing a really robust internal reporting system, and most big publicly held companies have them. But actually, one of the things I'm discovering from my program, which brings in a lot of compliance officers, but now we also do a director's academy, is I get to now meet people from what I think of as young publics, fast-growing publics, private equity companies. Those companies tend to be more on the cost minimization side of things, and they don't necessarily have a robust internal reporting system, and if they do, it may not be attached to a good data analytics thing to sort wheat from chaff. It may not be attached to a robust internal investigations system. So I'm hoping this will incentivize more of that. But the other thing that you learn is, and actually I think you've done some work on this, employees often don't report into an internal reporting system because they're often not sure it is a report, and that's so formal. And so they'll just raise it with their line manager. What do you think? Are you so sure about this? Or they'll raise it with HR. Or it won't come up until there's a disciplinary review, and then they'll say, well, whatever, I was thrown off by being asked to do this thing over here. And I think the best companies are really trying to reach down to line managers and saying, please don't do us a favor and kill these reports. We need them. But a lot of companies don't, and treat compliance as a program over here, a silo, and they don't realize that the line manager and HR are your first line of defense. I'm hoping this will start inducing companies to reduce silotization and start realizing that compliance has to integrate in with HR, as I've said before. Actually, compliance needs HR data. Compliance ought to be reviewing HR agreements. And I'm hoping that that will provide a lot of benefits and result in less crime that you even need to look at. But that may be my nirvana.
Please.
So I I guess what I would start off with is DOJ has put out a very robust set of questions called the Evaluation of Corporate Compliance Programs that I think many of you are familiar with. And I think that is a very useful starting point for a lot of companies, particularly if you're thinking about what if we end up in front of the Department of Justice someday, because that is a roadmap of the questions that you're going to get asked from prosecutors. And I think they want to see evidence that the compliance program is working. Now, I don't think that you should worry if you can't answer every question, because I don't think that number one, is realistic for a lot of companies, and number two, there's a lot of focus on certain areas that were added recently because it's been a focus of the department in terms of artificial intelligence. A lot of companies may not be using artificial intelligence. Even if they are, that may not be a significant risk for a company as many other types of business practices may be. So I would say that the most important thing is just to assess where your risk areas are. And to Jennifer's point, which I completely agree with, have conversations with the business. It shouldn't be compliance off on an island figuring this all out. Compliance should be having regular conversations with the business to try to understand what those risks are and what appropriate policies and controls can be put in place that are not going to be immediately circumvented because they're just unrealistic. And so, again, I think there's the, sort of utopian compliance program that if you followed every question and tried to do exactly what DOJ, you think DOJ would want, you may end up with a less effective compliance program than if you really just have a conversation with the business, try to figure out where your risks are, and try to figure out what policies and controls and procedures are going to actually do the best job. The last thing I would just point to, though, with an eye towards someday being in front of the department, is make sure you document the things that you do. And so to Jennifer's point, I actually think that managers in a lot of companies, and again, this may be a disagreement on the panel, but I realize that there are companies out there that are trying to commit wrongdoing. I think that the overwhelming majority of companies are not trying to make a profit by breaking the law. I think that most companies are trying to comply with the law. And so a lot of managers that are getting reports are reporting it up, but companies aren't documenting it in the same way that they are through an internal hotline report. And so I think documentation, which will put you in the best position to demonstrate to the department how effective your compliance program is really, really important.
Okay. Can I just toss in one thing related to documentation?
Just in case any of the companies that you advise are incorporated in Delaware, I would pay attention to what I call the Caremark 2.0 cases, where it's no longer good enough to report to the board on your compliance procedures and training. The board had better have a unit of the board designated to oversee anything that's a mission-critical legal risk, which I believe I've identified as anything that creates a real risk of customer loss or the potential of regulatory debarment or delicensing. And the board is supposed to learn about detected misconduct. And that's what companies are getting in trouble for, where the board doesn't ask about detected misconduct and document. So the documentation has to go all the way up.
Yeah, really quick, just to jump in on that. I think what we, all of our programs are tailored towards having companies design these strong compliance programs and making sure, sort of to Jennifer's point, that compliance executives have a seat at the table, that they're able to report directly. And I think, one point that Jennifer also made that's really important is tone from the top and training, because corporations are made up of a variety of different people. I think, Dan made the point there could be 2,000 people in a company and maybe there's 10 involved in the crime. But you need to train your managers at every level to be looking for misconduct, to be listening to people who are reporting, and then to pass that up to the senior executives who should have a seat at the table to talk to the board, to talk to the CEO.
I just want to conclude by thanking the Japanese Embassy, thanking Daisuke, thanking my fellow panelists. I definitely learned things as well. We're all pretty lucky, right? We're here today, and smart people from Europe, smart people from Asia, I don't know if smart people from the U.S., if I was speaking for myself at least, but at least people from the U.S. and some smart people from the U.S. And we're all fortunate to live at a time and in a place where we can get together and look at these issues. In terms of compliance, I think companies are much more focused on compliance than they were 20 years ago. By no means all companies, or probably any company, is perfect, but there is a sea change in a period of time when bribes used to be deductible as business expenses under some national tax code. So it's getting better. Keep trying. God bless you. Thank you all.
Thank you. And from me, so one thing, so I just want to update. So just, yeah, so Dan, you said document. I think it's a lawyer's word. So I think, I think in order to discuss the effectiveness of compliance program, I think data is also very important. And I think the discussion is, I think traditionally it's effort-based. So how, to what extent the employee attend the training, it's effort. But now I think it's evidence-based. So I think not only the evidence, also documents, I think, but also data and the data analytics, I think could be much more important in the future. So that is my additional comment. And thank you very much. So, and I hope so this discussion is helpful for you. Thank you so much.